And the last chapter for this week is chapter 5. So we're looking at intentional torts and negligence, which is a big chapter. This is the majority of your civil cases. Uh, Injured parties can bring a civil lawsuit to seek compensation or money for any wrong done to them by another party. This may be tort damages or punitive damages, and we'll get into that a little bit later. If the victim dies, beneficiaries can also bring it on behalf of the victim. Assault is the first intentional tort. The threat of immediate harm or offensive contact, any action that arouses reasonable apprehension of imminent harm. So any fear of getting hit, something thrown at you, shot, anything like that. Physical contact is not a necessary element of this tort. Battery is the other side of it. So this is the harmful or offensive contact with another person. Direct physical contact is necessary to the degree that there must be some sort of physical contact to the individual, but it could be, say, to their vehicle or to a purse that's immediately on their body. Those will count as battery as well. And then we have what's called the doctrine of transferred intent. So let's say party A intends to throw a arrow at party B, but actually hits party C. They are still going to be liable for what they did to party C. False imprisonment is another intentional tort. It's the intentional confinement or restraint of another person without the authority or justification to do so. This could be physical barriers, force, threats of violence, or even a false arrest. Shoplifting and movement are protected from false imprisonment if they have reasonable grounds that an individual is stealing from them, and the suspects are detained only for a reasonable period of time. Remember, those are very subjective, but the court usually holds a reasonable period of time to just conduct a mini investigation as to whether or not they were in fact shoplifting. We'll look at that case later. Misappropriation of the right to publicity. This is really looking at someone that's in the public eye. Attempt by another person to appropriate a living person's name or identity. So you use Jennifer Aniston's name to sell your iced tea or perfume without her consent. You're going to get sued for damages. Invasion of the right of privacy is another one that's traditionally saved for someone in the public eye. Anybody's right to privacy, if you are violating that, you can be held responsible. And then defamation of character. So we have two types, libel and slander. Libel is written, slander is spoken. And this is where a defendant makes an untrue statement of fact. The big thing on this one is to make sure that the statement is untrue. You can say something negative about an individual, but if it's true, then they are still going to be able to win in an action because it has to be an untrue statement. Disparagement is an untrue statement made about a product, or fraud, which is intentional misrepresentation. So if you're trying to deceive someone out of something, money, property. Intentional infliction of emotional distress is extreme and outrageous conduct that intentionally or recklessly causes severe emotional distress. When we say severe, guys, we mean extreme. It can't just be, I hurt someone's feelings. It has to be very, very extreme for the court to find damages in this case. And then malicious prosecution would simply be prosecution that is reckless or extreme. So a prosecutor knows that someone was not guilty of something and goes for it anyway. And then negligence is a little bit different because an intentional tort, you have to have an intent to actually commit that tort. Negligence, you do not have to have an intent. It's actually an omission to do something that a reasonable person would do. Elements of negligence are going to be duty, breach, causation, and damages. So we're going to look at the defendant owing a duty to the plaintiff. They breached that duty. The plaintiff, in fact, suffered an injury. The act was the direct result of the injury, and there was no way for them to mitigate that injury. Duty of care is an obligation not to cause any unreasonable harm. We're going to look at the reasonable person standard, which just is what applies to everyone. And then a professional standard would be someone of the same occupation that would be held to that standard. Say a doctor, attorney, anyone of that professional care. A breach would just be a failure to exercise that care. Injury, obviously, it can be physical or emotional or financial, but you have to prove there was an actual loss to the individual. And then causation. So you have to be, your omission of an act or act was the actual cause of the injury. So you, in fact, caused the car accident, or you have a product that, in fact, caused the injury to the individual. And there is a case that we will look at. And then we're looking at special negligence doctrine. So professional malpractice, professionals are held to a little bit higher standard than just a regular run-of-the-mill individual, and they must hold the same standard as someone in that same profession. Negligence per se is if we can't actually prove that the negligence was caused by the individual, but it is in fact more likely than not that the injury would have occurred from their negligence, the court can find them responsible. And res ipsa loquitur is along that line as well. Good Samaritan laws, in fact, are protecting individuals that say stop and help with a car accident, or providing CPR so that the individual can't be held liable for just helping an individual. And then superseding or intervening acts. So if another act happens in the duration of the individual's time of getting injured, they may in fact not be held liable if they can't discern whether or not their conduct was what caused the injury. So for example, let's say there's a car accident and it breaks an individual's bone, but at the hospital, the doctor acts negligently and they in fact lose the arm. The person that caused the car accident isn't going to be held liable for the loss of the arm because that's not what caused the loss of the arm. The doctor would be held liable for that. We'll look at that case. There are defenses against negligence. Contributory, which basically means the individual that was injured was partially at fault for the accident. And they will be reduced in their ability to obtain compensation for the part that they were held at fault. So if you were 50% at fault for the car accident, you're only going to be able to take 50% of that actual loss. Strict liability is a different doctrine altogether. It doesn't have anything to do with negligence, but basically if somebody is in inherently dangerous activity, they're going to be held liable. So if somebody runs a petting zoo with alligators and somebody gets bitten, they're going to be held liable for that bite because it's abnormally dangerous activity. Hopefully that helps. Again, email me with any questions.